I'm Nikki Jovicic from LookUpStrata, and I'm also the Managing Director of Tower Body Corporate, a body corporate management company in Queensland. I'm your host for this webinar, and we welcome back Chris Irons from Strata Solve. Although the word bullying doesn't appear in the legislation, we do hear a lot about it occurring in strata. Chris is providing us with information that will assist in recognising bullying type behaviour, and I believe it will be quite a practical session, providing us with takeaways to help manage these difficult situations. And before we begin, I'd like to mention that the information in this session, including the discussions arising from submitted questions and chat conversations, is not legal advice and should not be relied upon as advice, and you should seek independent advice before acting on the information contained in the session. So I know you all know Chris, but we're delighted to be joined again by Chris Irons from Strata Solve with an unparalleled perspective on strata issues. Chris Irons is a thought leader for the strata sector. For over 5 years, Chris was Queensland's Commissioner for Body Corporate and Community Management. Now, as Director of Strata Solve, Chris is an independent strata consultant, helping clients to untangle their strata issues with tailored practical solutions. Chris brings to the table over 2 decades of public sector leadership and policy development, and he's a nationally accredited mediator and a strong advocate for trying to resolve strata disputes without the need for legal proceedings. Welcome, it's wonderful to have you here, and thanks so much for joining us again.
Thank you, Nikki. My pleasure. Let's get into it then. Look, this is a topic that I know is confronting for some people, quite a few people, I expect, and may bring up some challenging things. So I want to make a disclaimer. Nikki's already made the disclaimer about legal advice, and I'll just reiterate that. The other disclaimer that I will make is that I'm not a psychologist. I don't have that training, and I'm not a counsellor. I don't have that training either. So I just want to make that disclaimer. I also want to give a trigger warning too, and this goes towards what I was just saying. Some of the content here might be a bit challenging and a bit triggering for people. It might bring up memories of difficult discussions or difficult interactions that you've had over the time, whether it's in Strata or elsewhere. Certainly not my intention to take you down that path, but I appreciate it might happen. So my very, very strong urging to everybody is that after today, as you need to, please do the most positive, proactive, constructive things that you need to do to debrief. If you've got family, friends, and colleagues that you can rely upon and trust and debrief with them, please do so. Go out for a walk, play with the dog, go to the gym, whatever. And if you do need to seek professional advice as well, please don't hesitate to do so. My focus today is very much on strata and how these topics relate to strata. I just wanted to sort of make that a bit clearer at the start, Nikki. I think that was probably not a bad idea. So with all that in mind, some of you might be wondering, well, what does he actually know about this topic then? Well, let's give that a go. So, as Nikki said, I used to be Queensland's Commissioner, and that's me, of course, standard shot in front of a building, and there is very little that I did not see, hear, or experience in that role. It really does expose you to just about every facet of strata, owners, corporation, body corporate that you can imagine, including the behaviours that go on. The other aspect which enables me, I think, to speak here is that I am an active participant in strata. So I am a tenant in a strata scheme, and you'll see here on screen my greyhound Ernest, who is also a tenant in a strata scheme. The technical name for that in Queensland is occupier. So I'm an occupier in a strata scheme. I'm also an owner in a different strata scheme. I'm not a body corporate manager. I'm not a caretaker. I'm not a lawyer. I exist in a space that sits in between all of those things and with all of those experiences. And dare I say it, it makes me a bit of a strata unicorn, I think. I think that I'm in a position to sit both outside and within some of these issues and have that perspective on things. So that's where I'm coming from today, and that's why I think I'm in a position to talk to some of these matters. I'm all about words, the written word, the communicated word. And for me, the first thing I want to say today is that You can't deal with something which does not exist. Seems logical, doesn't it? Can't deal with something which does not exist. As Nikki said at the start, and as has been said in the promotion for this webinar, the word bullying doesn't exist in strata legislation. Also, the words harassment, intimidation, gaslighting, abuse don't also appear in strata legislation. We can't talk about a subject and we can't talk about dealing with a subject if it doesn't actually exist in reality. Now, I know that bullying as a term and as a concept exists in a number of other contexts, in an industrial relations context in particular, and a few other contexts too. So I'm not talking about that, though. I'm talking about strata. Strata is unique. We always say that, regardless of the subject that we are speaking about. So my very, very strong recommendation and the basis on which I'm talking today is this. Let's eliminate bullying from our discussion and let's introduce this term, bullying type behaviour, or BTB, if you want to use an abbreviation. What I'm trying to do there is trying to make things inclusive. My understanding and experience of bullying is, I'm certain, different to Nikki's, and is, I'm certain, different to the 500 plus people and more who are watching this. I think everyone's experience just is slightly different. So if we use an inclusive generalist term like bullying type behaviour, I think that suggests to people, it gives a flavour for what we're talking about, but it does not limit it. And it also does not take us off onto tangents where our expectations based upon our other experiences in other scenarios come to bear here. I think this is a crucial way to deal with this tough subject, is to put into place a new terminology, some new concepts that we can all deal with. And that's the phrase that I'll be using throughout today, which leads me to the first takeaway of today's, of this webinar. Words mean everything in strata. I cannot emphasize that enough to everybody. I've just seen so many times that the use of words or the non-use of words contributing to a situation. I'll give you another example to illustrate what I mean. Did you know that the word breach does not occur in strata legislation? There's no such thing as a bylaw breach. It's a bylaw contravention. Now, you might say, well, it's the same thing. Actually, it's not quite the same thing. Moreover, though, you think about those words. Breach is a harsh word. It's dare I say it, it's a bit of a violent word. It's impactful and it suggests certain things, a breach. Contravention, if you think about how that sounds and how it rolls off the tongue, is a different word. It's a little more benign. It has a little less impact. Words mean everything in strata. If you're going to take one thing out of today, please take that out of today. All right, so if we're going along this path of BTB, then I think BTB is always about feelings and experiences. You have to be able to feel and experience something. What does that actually mean? I think it means a few things. First of all, I've racked my brain on this one a lot leading up to this webinar and thinking about this webinar. I cannot think of a situation in which bullying type behaviour could be a positive or a constructive experience. I just can't think of one. So to me, it's not positive. Bullying type behaviour is based upon experience and interaction, be it with individuals, be it with groups, and in a variety of situations. And then the third aspect is bullying type behaviour is about impact upon our perspective, about the way we think. I think there's also an impact upon rationality, logic. The number of times that I have seen and experienced people in strata situations, people who are very successful, very astute business people, professionals, lawyers, accountants, teachers, doctors, members of the judiciary, members of parliament as well, who I have experienced they have a stake in the strata scheme, but as soon as strata gets involved, that rationality that's gotten them to that success in life tends to go by the wayside. That's another aspect of BTB. So the second takeaway I'd like everybody to ideally leave with out of this. I want to make this point really clear. Your strata interests are really important. Your strata investment is exceptionally important. There's so much money at stake. It's not the most important thing, though. The most important thing is you, always. So if you're feeling and experiencing bullying type behaviour, whether you're an owner, whether you're a committee member, whether you're a strata manager, whether you're a caretaker, whether you're a service provider, your first priority is yourself, always. Get support self, get help first, feel more assured first, and then worry about the strata stuff second. Worry about you enforcing your strata rights, your meetings, your notices. Worry about that second. Deal with the impact first, worry about strata second. If we're going to talk about bullying type behaviour or BTB, we need to know what the indicators are. So I've prepared a list of what I think the red flags about bullying type behaviour are. Now, remember, we don't have a shared definition of bullying. We're talking about bullying type behaviour. So these, in my experience, are the indicators that bullying type behaviour may be occurring. This is not an exhaustive list, and it doesn't mean that you have to tick every one of these like a checklist to get to a result. It may well be, depending upon the circumstances, you just experience one of them. That may be enough, depending upon what is going on. So exclusion is a good red flag to keep in mind. So exclusion here, it could be, for example, you're a member of a committee and you don't get notices. You don't get invited to a meeting. You don't get invited to a discussion. Your email invitation mysteriously goes awry for whatever reason. Exclusion is typically a red flag. Inconsistency is another red flag. So again, an example of inconsistency is inconsistent application of rules or inconsistent application of bylaws. If there's a bylaw which is being enforced against one person and then roughly the same behaviour is occurring with another person, but the bylaw is not being enforced against them, that's an example of inconsistency, and that contributes to a feeling of bullying type behaviour. Then we have verbal aggression. I think that largely speaks for itself. I guess there I'm talking about, people being rude, people being aggressive, passive aggressive. Verbalization, I think, is another example there to keep in mind. Verbal aggression, and then of course physical aggression as well. Now, physical aggression is part of your strata experience. I would be suggesting to you that's typically a police matter. That's not a strata issue. That's a police issue. And that is, I guess, at the extreme end, if you like, of the spectrum of red flags that we're talking about. Let's keep going. This relates, I suppose, to verbal aggression. Tone. Tone is a tricky one. You can probably get a fair idea of tone when you're speaking to someone in person or over the phone. Much hard to get tone out of emails. The temptation is there to interpret a tone from an email. I just exercise a note of caution on that, because so many times I have seen an email where you think there's a particular tone to it and it's not there at all. And I've got a couple of other sort of aspects of that I'll touch upon shortly. Another red flag is a high volume of email or calls, and closely related to that is the time at which emails are sent or calls are made. If you're getting emails at 11 o'clock at night, that's not great. That's not great. Getting a lot of emails at about 9 and 10 o'clock, I think, while I'm not saying that's acceptable, you can understand that a bit more, because that's business hours that we're talking about. There's no set number to qualify as an excessive or high volume of emails or calls. In Queensland, adjudicators have considered this issue in several adjudicators' orders, and they come to roughly the same conclusion, that it's about case-by-case situation. There's no set number that needs to be achieved. But I guess I come back to my earlier point. It's about feeling and experiencing. You might get 10 in the space of a couple of hours, but because of the intensity and the phrasing and the words used, that contributes to a really strong feeling as a consequence. This next one might be not so much a surprise, but one people haven't thought about a lot, and it's body language. This only, of course, applies to situations where you can see another person. Typically, it will apply in an interpersonal interaction, but it might apply also to a Zoom meeting or a Teams meeting as well. So here's a fun fact for everybody. When I was at university, one of the things I studied was body language as part of my degree, the theoretical constructs behind that. One of the things you learn about that is that while we can generally control our words and our language, it is far more difficult to control body language. That's usually something we don't have a great deal of control over because it's inherent to ourselves. So if, for example, you're used to a fairly good interaction and relationship with somebody in your strata scheme, be it your manager or a committee member or another owner, and it's been good, and then all of a sudden you're starting to notice a lot of folded arms or a lot of tilting of the head away from you or a lot of stepping back from you or a lot of distance, physical distance I'm talking about, between you and the other person where it wasn't there previously. A really good indicator of this one is the positioning of chairs around a table for a meeting. And you might think to yourself, well, that doesn't mean anything. It actually means a lot. As Nikki said in the intro, I'm a qualified mediator, and there is an awful lot of work that goes into the positioning of chairs in a mediation session. I attended not that long ago a committee meeting with some clients, and they wanted me to go along because they were feeling some BTB. I went along, and the way in which it was all set up was that you had all of the committee sitting on one side of the table and us sitting on the other. I didn't feel good about that, and I knew, but I could see that that was quite a deliberate action from all of the parties involved, and you won't be surprised to learn that discussion didn't go ideally, and it couldn't go ideally under those circumstances. When I realised what was going on, I shifted my position in my seat. Like I pushed back from the table slightly and put the chair on an angle so I appeared more open. But I couldn't control what my clients did, and I saw them actually getting closer and closer to the table and hanging on to the edge of the table. Those are giveaways that some BTB are happening. And then closely related to that, another red flag, formality changes. So if you're used to talking to John in a strata meeting, John being your chairperson, your strata manager, whomever, and that's been fine. And then you start to get emails where John is being replaced by chairperson, John is being replaced by secretary, or you're used to dealing with Mavis in lot one, and then suddenly the references become the owner of lot one or the occupier of lot one. A formality change indicates that something has not gone right or something is going wrong, and that can be a red flag as well. A few more responsiveness changes. If you're used to pretty good responsiveness from somebody, that you get an email reply back in a half hour, and then suddenly it shifts out to 3 days or a week or none at all, that is a pretty good indicator that perhaps something has gone awry. Using third parties is a red flag as well. So getting a lawyer or getting a strata consultant involved can be a red flag that there is a feeling of negativity involved in the situation. Now, ultimately, the use of that third party might assist to resolve the situation. That's a good thing. But the action of getting a third party involved can indicate a problem. And then word choices is another good red flag. And I've listed a few there. If you're seeing emails with those kinds of words in there, that to me indicates that the relationship is not quite what it could be. The interactions are not what they should be. This slide I've labelled Confronting Discussions, and it's confronting because I'm going to pose to everybody watching a couple of questions that you might not want to think of, but I think it's essential that you do think of them. So I just want to put that up there in advance. And I'm not trying to blame anybody. I just think it's important to raise these issues. So the first one, you might be experiencing negative feelings and you might think to yourself, it's bullying type behavior, but I want to draw your attention to the fact that what you're experiencing actually is possibly 100% appropriate for the circumstances. So if you receive a contravention notice about a bylaw, that of itself doesn't necessarily mean you are experiencing bullying type behavior, even though it provokes a strong reaction within you. It might actually be entirely appropriate for the situation. And then there are two questions I think we need to be asking ourselves at all times. Are your expectations realistic under the circumstances? Number one. And number two, are you exhibiting signs of BTB? Are you saying or doing something which is adding to the situation? I fully appreciate that those points will not necessarily be to everybody's liking. I apologize in advance for that, but I cannot have this discussion without raising those points to people, because the only thing that we can control in these situations is ourselves. We can't control others. We can't control other reactions. So I think it's essential. You need to put yourself through that kind of personal interrogation, which then leads to my next takeaway. With all of those red flags in mind, you heed the signs and heed them early. The worst thing I think that you can do is identify some of those red flags, but not do anything about it, not act upon it. By all means, consider it, reflect upon it, and I'll talk about reflection shortly. But if you reflect upon it and don't do anything with it, that's not the ideal in this situation. So in thinking about bullying type behaviour, I turn my mind to, does legislation actually help us anywhere with this? So while it doesn't mention the word bullying, does it help us at all? I actually think it does in a number of cases. And here's what I came up with. Bylaw enforcement, first of all. In Queensland, there is a very, very, very well-known case in which someone's behaviour got well and truly regulated by an adjudicator's order through a bylaw enforcement, to the point that the number of emails and letters that they could send to the committee were restricted by an adjudicator. So bylaw enforcement can offer something. Queensland also has provisions for nuisance, hazard and interference, and those things could also be relied upon to address a bullying type behaviour situation. Then you've got owner motions. Owners have the right to submit motions to a general meeting and also under Queensland legislation to committee meetings. So that is your right to seek action be taken in a given situation. So that's a right that you have. A few more things. Your general voting rights. Legislation gives you the right. So I always say to people, the number one weapon anybody ever has is their ability to cast a vote. And that applies in any kind of election, but it applies here as well. You have the option to nominate for a committee if you're an owner. That's a way of being involved in the process. Access to records is a big thing when it comes to this sort of thing. If you need to pursue anything, if you need to do anything, you need to have information, you need to have an objective basis. Accessing the records is how you achieve that. And finally, the legislated dispute resolution processes. In Queensland, we have my former office, the Commissioner's Office, which offers conciliation and adjudication. And yes, sometimes bullying type behaviours do result in adjudicators' orders in Queensland. Of course, if we're going to identify what legislation gives us, we have to look at what it doesn't give us. And there's quite a few things you won't be surprised to learn. Doesn't give us minimum conduct standards. It gives us some conduct standards if there's a code of conduct, for example, but largely those codes of conduct, in my view, are aspirational. That's fine to have an aspirational code of conduct, but there's no such thing as a code of conduct for an owner. There's no such thing as a code of conduct for an occupier. There's no such thing as a code of conduct for how you will behave at a meeting. That doesn't exist under legislation. There's also no such thing as minimum qualifications, largely. There's no minimum qualifications to be on a committee other than you be an owner and you be financial. So there's no like education or experience qualifications. There's no qualifications to vote or to make decisions other than the fact that you are financial and you're an owner. And in Queensland, there are no minimum qualifications to be a strata manager either. That might change, but that is still the case. You also are not obliged to participate. You could be part of your strata scheme for 2 decades and not vote, never return a paper, never read a document. Legislation does not mandate your participation. Legislation also does not give you equal rights. The rights, for example, between an owner and an occupier are not the same. The rights between an owner and a caretaker are not the same, even if the caretaker happens to be an owner. They still don't have the same rights as other owners. There are also not unlimited rights. Rights are limited by various legislative qualifications. A few more things. Legislation does not provide for any of those things. Manners, morals, ethics, respect. It'd be a great world if it did, and I think we can all agree that we would like those things present. But legislation doesn't do that. And I'm not familiar with other legislation which does, because those things are subjective. They're very difficult to define and even harder to try and enforce. So just remember, as much as you would like those things, as much as we would all love those things, they don't exist under strata legislation. So, which leads me to my next takeaway, takeaway number 4. I want to make this point really clear. If we're picking up on those legislative options, in my experience, for the vast majority of situations, formal proceedings always fan the flames. So you think that you're experiencing BTB, I'm going to take proceedings. I'm going to take them to court. I'm going to sue for defamation. Okay. It doesn't necessarily make it better. And in my experience, it typically makes it worse. Not every time, but most of the time it does. Keep that in mind. I'm not criticising lawyers. I want to make that clear. And I'm not criticising legal proceedings. There are some cases where that's completely unavoidable. Most cases, though, and especially the things we're talking about today, don't require proceedings, in my view. So then, solutions. We've gone through all of those things. Here's what I think could be looked at. Your very first step, pause, reflect, inhale. You've got to stop. You've got to step back. Otherwise, you just will have no perspective and your well-being will suffer. Remember what I said before about look after yourself first and take care of strata second. You've got to do that. Then, number 2, have those confronting discussions that I highlighted on the earlier slide. You must ask yourself, in my view, you must ask yourself those questions. You might actually find that there's something there that you would prefer to do differently about yourself into the future. I know there are a number of occasions where I would have preferred to have done something differently in a particular situation. You've got to have those confronting discussions, which then leads you to 2A. Self-reflection. I know a lot of people think that self-reflection could be viewed as a sign of weakness. I know that and I accept that. I just don't think it is for strata. If you can reflect upon yourself, your participation in a situation, I think that puts you in a much better position to be able to do something about the situation. Then we get to point 3, log. And by log, I mean record or evidence or compile. You need to know what's going on. So if you're saying, I'm feeling and experiencing BTB, okay, let's try and actualize it then, whether that's a diary, file note, log, recordings, whatever the case may be. Serves 2 purposes. Number 1, if you do need or you have to follow through on some proceedings, you'll need that evidence. But number 2, and the bigger thing for me, getting it on the page takes some pressure off you. It's a release for you. You can see it existing there on the page. It's like, okay, I now know what I'm dealing with. I'm starting to feel slightly less challenged by the situation. Number 4, get a buffer involved in this. There are many different buffers that you can use in Strata. Appoint a proxy, or consider appointing a proxy or a power of attorney or a representative or a support person for Strata meetings. That is something that I do and have done many times for clients. It's also about putting a buffer between you and another party with whom you're experiencing some challenges or you're having some triggers. And again, that's something I've done a lot for clients. Being that buffer, having a buffer, and this is also a good thing, I think, for Strata managers, having a buffer between you and perhaps the source of a challenge is a great thing. And that might mean that for a period of time, somebody else picks up the phone, or somebody else might take over for a day or two, or in worst case scenario, somebody takes over that portfolio responsibility, or you just have a timeout. Timeouts can be buffers as well, but you need a buffer in the situation. We'll keep going. Engage. I'm not necessarily talking here about engaging with a person who's causing you distress. I'm talking about engaging with others. There are many, many different parties in a Strata scheme. You engage with them differently for different reasons because they have different roles, but you need to engage. I don't think being solo in a Strata scheme is always a good idea. And that leads very closely to point 6, lobby. Strata and politics are very, very similar. You try and get the numbers to try and get the outcome. So if there is something that you want done in a Strata scheme and it is going to be something that might improve your BTB situation, think about lobbying for support from others to get you to the point where you can get that happening. Number 7, intervene. So intervention here can take a few forms. It might be legal proceedings, and it might be a very specific kind of legal proceedings. And it might be just one proceeding, or it might be a couple, but the intervention in the situation is that circuit breaker that's required to diminish those feelings of BTB. Intervention might be the appointment of a manager or an administrator or some other party who changes the dynamic. That's what we're talking about with intervention, changing the dynamic, which then leads us to number 8, change. Something has to change. If bullying type behaviour is being experienced and felt, something has to change. Whether that's your approach, whether that's somebody else, whether it's a scenario, whether it's a location, whether it's a meeting, whether it's an individual, something must change, which leads to my final takeaway. Bullying type behaviour absolutely loves inertia. It absolutely loves. I've said so many times over the years that I've been involved with Strata to people, nothing changes if you don't do something about it. The situation remains. So take as much control and ownership as you can of a situation and be seen and be feeling to do something about it. If you let it lie, it's more likely it's going to intensify. But if you do a few things, even if they're small things, that sense of action, that sense of productiveness can really be a great way to overcome some of those feelings. That is the end of the presentation.
Thank you so much for that. It was great to see the action points at the end. I think there were 8 of them. Is that correct?
That's right. Yeah.
Okay, so 8 action points that people can refer back to and hopefully use, and they will assist them with the behaviour that you've mentioned during the presentation. Just one quick small thing. I think you mentioned that the word breach doesn't appear in the Queensland legislation. People have just been popping comments in from other states saying that it does appear in different legislations from around Australia. So just to let everybody know,
All right.
This was mentioning Queensland legislation at that point, and as an example, I think, of just the way terminology is used within within legislation in Strata. So the first one we have here is bullying and harassment occur within our complex. The culprit is the committee member, and I'm on the committee also. The bullying and harassment has happened for a couple of years now. Recently, dog poo was placed in the boot of my car. I feel this action responded to my not obeying their unreasonable and bullying style requests. It affects my health, and I simply want this person to leave me alone. I know bullying isn't recognised by the laws that govern body corporate, and our body corporate manager just turns a blind eye. What avenues can I take to stop this? I don't feel safe attending meetings, but I'm keen to continue to hold my position on the committee.
First of all, that doesn't sound great at all. So I hope you're okay, whoever posed that question, and I hope you've got some good people around you to offer you some sort of support, some guidance, and similar kinds of things. I would wonder if some of those actions may, and I stress may, involve the police. I would tend to think perhaps it would, based upon what you've read out there, Nikki. But okay, but that maybe you keep that aside as a more extreme response. I think the important thing out of your question, the bit I've really picked up on, is the I want to continue to be involved bit. That's okay. So that's key to me. All right, you've established a very clear outcome in your mind. I want to continue to be involved. That's great. Fantastic. What is the minimum that you need to be able to do that? So you don't have to do everything. You don't have to be Superman or Superwoman. You don't need to wave a magic wand, but what's the minimum that you would need done differently? I can see situations in which you can be part of a committee and not necessarily have to talk a great deal to another committee member. That, it's quite, you can put yourself in situations where you can really regulate how much you deal with another person, if it is about that person. And it seems like that's what you're suggesting that it is. So that would be my suggestion to you. Establish the minimum you need to carry on, and then think about how you regulate your interaction with that person, whether it is focusing on email voting or email interactions, or again, thinking about that physical aspect. If you're in a meeting situation, physical meeting situation, think about where you are positioned in the room. Look to have your supporters, people who you can rely upon, sitting next to you. Buffer, support, change.
Okay, thanks, Chris. So what's the difference between bullying and defamation? And we did have quite a few comments and questions that came in about defamation. So, I'd love to hear your thoughts on that.
Yeah, so I think the best thing I can do here, Nikki, and I hope I've given the link there to you. Frank Higginson and I have done a webinar about defamation in Strata. Fingers crossed, Nikki, that I left the link there for you. If it is there, I recommend maybe chucking it in the chat so that everybody can have a look at it. It's fairly short. It's about half an hour-ish, I think. Defamation is very much a legal proceeding, a legal issue. Frank isn't here, and I don't want to speak for Frank, but I know Frank is fond of saying to people, you don't embark upon that process unless you fully intend to see it through. So you need to, and it's not necessarily cheap either. I think we'd all be aware of very high profile cases that in Australia relating to defamation. Some of the costs that have been quoted have been eye-watering in those situations. Always keep that in mind, I'd be suggesting.
Okay, and with that recording, I will certainly send a copy of the link out for everyone so they can go and have a look at it. Is that applicable for all states, Chris, or is it more applicable for Queensland, or because it is national?
Yeah, my understanding is that defamation laws are generally uniform. I'm not a lawyer, so don't quote me on that, but that's my understanding, Nikki. Yeah. Okay. Some of the specifics about defamation and strata will differ from state to state, for sure. Yeah.
But as always, we recommend you maybe have a look at the video, get some ideas from that, and then seek your own legal advice.
Absolutely. Yeah.
Sure. So that should help. Okay. What do you do when bullying office bearers make sure critical decisions are scheduled as electronic EGMs, so no discussion in a public manner can take place? They did this with our body corporate change when our body corporate changed strata managers, so we couldn't influence the change or offer an alternative manager to the one that they put forward.
Okay. Yeah, look, good question. My view is that if you are seeking to influence decisions in your body corporate, be it part of a meeting, your work always happens before the meeting. It must happen before the meeting. If you're leaving the opportunity to influence to the meeting itself, it's too late, in my view, because by that time, most people have made up their minds, or, and I've seen this happen in person, they resent the fact that their time is being taken up with discussion. I've been at strata meetings with clients where I've seen eye rolling and sighing and tut-tutting. By all means, if there's an opportunity for chat at the meeting, take it, but use it wisely is always my suggestion. Succinct, simple messages that focus on positive, constructive outcomes. Here's what we would like people to do, and here's why we'd like them to do it. And here are the benefits of doing it. Standing up on the soapbox and speaking for a long period of time and leveling accusations or criticisms in the meeting, I don't think is going to get you your outcome. Remember, strata meetings are for decisions to be made. They're typically not forums for discussion. They're not. There is, for example, no such thing as general discussion at a strata meeting. You can have it for sure, but it has no effect. It has no force. So you've got to make distinctions between the decision-making functionality of your strata meeting and your persuasive communication efforts, which should always happen beforehand. My experience in dealing with this with clients, you usually don't leave it any later than 2 weeks beforehand, because that's usually the point where people have either started to vote, started to make up their mind. You're losing your opportunity after that, in my view.
Okay, thanks, Chris. And we've had a bit of a side discussion going on in the chat just about the ability for lot owners to attend committee meetings. And I think that is legislation. Of course, the legislation differs in every state, but I think there is legislation in at least most of the states that allow through invite. You have to usually apply, don't you? And then
that's right.
You get to let them know, and then you usually granted the permission to go along. And there's even a provision, I think, to speak at those meetings if you apply beforehand.
Yeah, look, it's like in Queensland, it's incredibly strict. And people I know are quite surprised and unhappy about this when they learn about it. You do not have an automatic right as a non-committee member to attend in Queensland. I'm only speaking from Queensland now. So you don't have an automatic right. If you do get approved to attend, and I'll share this with you, I've been declined to approve committee meetings in the past. It's happened several times. If you are declined, you're declined. If you're approved, then there are some fairly strict conditions on your participation. Effectively, you don't speak unless you're spoken to in those meetings. And then there are certain issues on which you must leave the meeting if they come up. So, for example, a discussion about bylaw enforcement. Regardless if it involves you, you still have to leave the meeting as a participant. You can quibble a query if that's the right way to do it. I take everybody's point that that might seem a bit unfair or a bit restrictive, but there are reasons for it. And remember, you still have rights to submit motions to both committee and general meeting.
Okay, and we've just had a comment come up about a meeting as well, saying, can you ban someone's attendance because of their threatening or bullying behaviour?
Look, God, that's a good question. My personal view, and that's all it is, Nikki, is that there should be a legislative provision around this. It's come up far too often for it to not be an issue, but there isn't. But there are other ways that you can deal with it. So we start from the position that if somebody is an owner and they're financial, then they have every right to participate and they have every right to attend. You cannot do anything about that at this stage. What you can do, though, if you hold a meeting, for example, in somebody's private premises, you're perfectly entitled to regulate who comes in there. Maybe that's something that you think about. What I would be suggesting from a practical perspective, I've had this issue come up a couple of times, Nikki. I had one client just recently, in fact, where they had this very issue, and the client said to me, what can we do about this person? They're very disruptive. Can we ban them from the meeting? No, you can't. All right, what can we do about it then? Where we got to in the end was that they were the kind of body corporate where they are a large number of townhouses with common facilities and a kind of gated community. And they had like a central area, which was a pool, kind of like a semi-clubhouse, if you like, a little bit of garden. They decided to hold the meeting there. I thought that was a really wise idea. It's in the open. It's on common property. You don't have that feeling that the walls are there and are restricting, but also contributing to that feeling of aggression, if that's what you're worried about. But I will say this to people. If you were worried about somebody attending the meeting because of their behaviour, there's actually a lot of strategic benefit in letting them attend. Because in letting them attend, everybody sees what's going on. You get them to expose themselves. So if that person, for example, then thinks that they're going to get voted on the committee, let them go to the meeting. Let them make a complete fool of themselves, Nikki. They're not going to get voted onto the committee after that. Not only that, if they then put up motions to meetings, they're hardly likely to get support for that. So let them make a fool of themselves. I know it might be difficult. And look, if any of behaviour veers into aggression, physical interactions, absolutely, it's a police issue. Otherwise, let them make a fool of themselves.
Okay. And then leading on from that, probably as well, we were asked a question from a strata manager saying, how do you deal in a large AGM with bullying? So you've covered that to some degree there, although I'm not sure if you wanted to add anything to that, but then saying, what if you ask the person to leave and they refuse? So would that be a police matter if that's the case? Or
depends where the meeting's being held, I think, Nikki. Yeah. So, and depends upon also the lead up to it as well. Remember that if you are concerned about this person and then didn't invite them or didn't send them a notice, then that's excluding, which is one of the red flags that I spoke about earlier. So you need to be conscious of that, but you also need to be conscious about their rights as an owner. I put up a social media post not that long ago. I can't quite remember, or maybe I haven't done it yet. But the idea that if there is a particular order or conviction against an owner for some kinds of behaviour, they should actually forfeit voting rights. I actually think there's a lot of sense in that and something for regulators to look at.
Okay. And another strata manager, I think, in an instance of aggressive bullying members attending the AGM, the committee were pre-warned and agreed to have security guards present to remove them if necessary, and they ended up leaving of their own accord after being asked.
I've heard of that too, Nikki. Oh, that's not... It's not a good situation. I really feel for people in that situation. Yeah.
Okay. All right. We had one. We have a lot owner who has written and is distributing a document that defames current members and a former member of our management committee. What remedies are available? I'd like to know what actions are available to the strata manager and the management committee. So does that just go back to the defamation one that we were speaking about earlier, Chris?
A little bit, Nikki, but also I'd say to that person, look, it's tough work when you see things floating around which say things about you or somebody else that you know, and perhaps they're not correct, or at least they're not very nice. My first question, or the first thing I think you need to think about, do I need to do anything? Do I really need to do anything about that? As difficult as it is to see those words and to hear them, do I really need to do anything? Remember, in doing it, you are taking action, and there are certain people in this world who love the idea of a fight, and they would love nothing more than the opportunity to have their day in court and talk about why they did what they did. Don't fuel the fire if you don't have to fuel the fire. If there's an opportunity, ask the person, why are you doing this? Why are you sending this? If you can engage with them, if it feels safe to do so, why? What's going on here? It may well be that there is a completely separate matter lying behind that you can actually address. If not, though, there are certainly provisions around bylaws, around nuisance, that certainly from a Queensland perspective, that would possibly apply to that situation, Nikki, and about restriction on communication as well. And then, yes, whether it's defamatory or not, if you think it is, you'd need to seek legal advice at that point.
Okay, and I just we're coming right up to the end of the session, and always we never get a time to go through everything, but one of the things I wanted to mention is we did receive an unusual amount of emails from caretakers saying that they feel they've been bullied by either owners, residents or other committee members, and they gave plenty of examples, things like after-hour calls or visits to their lot, banging on their door at all hours, being abused while they're working, or the boundaries are not being respected, and unrealistic expectations about their duties and the way they've performed them. And they question whether the behaviour could be called bullying. And we don't really have time to go through them all, Chris, but that's just a summary of what we received. So I thought I'd mention that to see what your comments were.
Probably the only, when it comes to caretakers, management rights holders, well, they've all got different words, different kind of descriptors, Nikki, depending on state and territory. That might be a slightly different scenario, because I am aware of at least one case that went to the Fair Work Commission involving a caretaker and in relation to bullying. I am not an industrial relations expert, Nikki, so I couldn't say what happened and what needs to happen, but that is a slight difference. But I think all of the concepts that I've discussed today still apply regardless. Sorry, Nikki, I forgot. I didn't put up contact details.
Wonderful. So you reach out to Chris, definitely. Yeah, he's a great resource for everybody. We certainly reach out to him all the time. Very, very high number of emails going backwards and forwards. Before we go, Chris, I'd just like to mention that someone else in there, a Strata manager, said that they also experienced this type of behaviour that we were just speaking about, of course, with caretakers. So that's something we need to consider as well.
Yeah, for sure, for sure. Like I say, workplaces, a slightly different scenario, and there may be other possibilities. So they would need to be investigated, but all of the tactics, all of the methods, all of the points made today still apply. Yeah.
Okay, excellent. Thank you so much.
Thank you, Nikki. And again, thank you, everyone. It's not everybody's favourite topic to be talking about. I get it. It's important, though, that we don't run away from it, everybody, and we think about what can we do practically. And I hope that that's what everybody leaves with today.
If you gained value from this video, please hit like and subscribe to our YouTube channel. If you're looking for information about parking, strata insurance, defects and more, head over to lookupstrata.com.au or sign up to our free weekly newsletter via the link in the description box below.